Question 1. December 2018. Law 416. Hannah bought some fried chicken from the restaurant Hoppy Fried Chicken. She was then hospitalized for food poisoning after consuming the chicken. Hannah wanted to take legal action against the restaurant Hoppy Fried Chicken. Advised Hannah on her rights under the Sales of Goods Act 1957. The issue is whether restaurant Hoppy Fried Chicken has breached the implied conditions of quality and fitness purpose under the Sales of Goods Act 1957, which resulted in Hannah suffering food poisoning after consuming the restaurant's fried chicken. The law that being applied in this case is Section 16, Clause 1, Clause A, states that there is an implied conditions that the goods will be reasonable fit for the particular purpose for which they are bought. The first requirement mentioned that the buyer must have known to the seller that the particular purpose for which the goods are required. Then there is an implied condition that the goods shall be reasonably fit for that purpose, either expressly or impliedly. Based on the case of Priest against Last, the plaintiff purchased a hot water bottle from the defendants, a retail chemist. Some days later, the bottle, while in use by P's wife, burst. As a result, she was scalded and the P sued the D. The court held that the descriptions of the goods by which they were sold pointed to one particular purpose only. Then the requirement of disclosure of purpose is fulfilled. Applying to the case, the buyer Hannah made known to the seller, restaurant Hoppy Fried Chicken, that she wanted to eat the fried chicken to filling her stomach. As the restaurant Hoppy Fried Chicken served the fried chicken should have been fit for those specific purposes. Therefore, the first requirement is fulfilled. The second requirement is the buyer Hannah must have relied on the seller's skills and judgment, either expressly or impliedly. Based on Mesh and Mural against Joseph Emmanuel 1961, the sellers in Cyprus sold potatoes carriage and fringe to Liverpool. The potatoes were sound when loaded, but rotten on arrival in Liverpool. The court held it was the sellers were liable in such a contract. The goods should be loaded in such a way that they can endure a normal journey and be in imaginable conditions upon arrival. Applying to this case, the buyer Hannah seized the fried chicken and Hannah expected the fried chicken is safe to be consumed, but unfortunately it caused food poisoning, which means it was not fit for the intended purpose of safe consumption. Hannah, the buyer, trusts the skills and judgment of the seller to serve the fried chicken in good conditions. Therefore, the second element is fulfilled.
The third requirement is the good bought by the buyer must be kind, which is in the course of the seller business to supply, referring to the case of Spencer Trading Co. Limited against Devon. The manufacturer had previously supplied to the plaintiff on a special order an adhesive substance made from gum resin for making fly papers. The following year, the plaintiff ordered a further supply for the same purpose from the manufacturer, who, on acquisition, used synthetic raw material in the place of the natural material previously used. Consequently, the fly paper was unsatisfactory for its purpose. The court held that the goods are of the description which is in the course of the seller's business to supply. Therefore, the manufacturer was liable for breach of implied conditions, that is, that the goods are fit for the purpose of a purpose for which they were required. Applying to the case, the seller was expected to prepare food well, and the responsibility of a restaurant is to ensure that the food is fit for its purpose. However, Hannah get food poisoning from the fried chicken that they served, which resulted in her being hospitalized. The court held that it was found that the restaurant Hoppy Fried Chicken has used the same fried chicken from the previous day as it is not sold out, and as a result, they breached their obligation. Therefore, restaurant Hoppy Fried Chicken is liable for breach implied condition that the fried chicken sold were fit for the purpose for which they were required. Therefore, the third element is fulfilled. The first requirement mentioned that the goods were not bought under a particular patent or trade name. If the buyer asks for specific goods under a patent or trade name with the impression that he is not relying on the seller's skill or judgment, he cannot later complain if the goods bought are not for the purpose which he requires them. If the buyer purchased the good under a trade name and relies on the seller's skill or judgment, this means that the buyer is relying on the seller's skill or judgment. In the case of Frost against Aylesbury Dairy Company Ltd. 1905, the defendant in this case is a milk dealer where he supplied milk containing germs of typhoid fever. Plaintiff's wife died due to the infection. The court held that it was an implied condition that the milk must be reasonably fit for consumption. Applying to this case, Hannah relies on the restaurant Hoppy Fried Chicken to serve fried chicken that is safe to consume by its customers as its trade name is to serve fried chicken to the customer. Hannah expected fried chicken to be an edible food which is standard and reasonable. But the fact is the fried chicken is poison which causes her to be hospitalized. Therefore, the fourth requirement is fulfilled. In conclusion, since the law is fulfilled, Hannah can sue Restaurant Hoppy Fried Chicken under non-merchantable quality and outfit for purpose.
Question 2, December 2016, Law 416. Raya Sendirian Berhad manufactures various types of household goods. These goods are distributed to retailers around the Klang Valley. One of the retailers was Ramli. Dini wanted to buy an oven for her bakery. Ramli recommended an oven to Dini. The oven sold to Dini was defective. It exploded while being used by Dini. As a result of the explosion, Dini and her workers suffered severe burns and a part of her bakery was burned down. Advised Dini as to her rights against Ramli. The issue is whether Dini can take legal action against Ramli based on implied terms of contract under Sale of Goods Act 1957. The law is two implied conditions as to fitness for particular purpose. Section 16 Clause 1 Clause A mention that there is an implied condition that the goods will be reasonably fit for the particular purpose for which they are brought. The first requirement mentioned that the buyer must have made known to the seller the purpose for which he has bought the goods, either expressly or impliedly. Based on the case of Priest against Last, the buyer bought a hot water bottle. The bottle burst and injured his wife. The court held that the hot water bottle has only one purpose in ordinary course of events. Thus, there was a breach of implied condition that the bottle fit for its purpose. Applying to the case, Dini made known to Ramli that she needed the oven for her bakery. The oven provided should have been fit for those specific purposes. The fact that when Dini uses the oven for baking, the oven explodes. Thus, there was a breach of implied condition that the oven fit for its purpose. Therefore, the first requirement is fulfilled.
The second requirement is the buyer must have relied on the seller's skill and judgment, either expressly or impliedly. Based on the case of Grant against Australian Knitting Mill, the court held that rely usually arises by implication from the circumstance. For instance, of a purchase from a retailer, the rely will be inferenced from the fact that a buyer goes to the shop in the confidence that the seller has selected his stock with just and skill. Applying to this case, Dini asked for Ramli's recommendation over the marketable goods or oven to bake in her bakery. Dini trusts the skills and judgment of Ramli to recommend and choose which oven is the best for the cooking. Therefore, the second requirement is fulfilled. The third requirement is the goods bought by the buyer must be the kind which is in the course of the seller business to supply. Referring to the case of Spencer Training Company Limited against Devon, the manufacturer had previously supplied to the plaintiff on a special order an adhesive substance made from a gun resin for making flypaper. The following year, the plaintiff ordered a further supply for the same purpose from the manufacturer who on occasion used synthetic raw material in place of the natural material previously used. Consequently, the flyer paper was unsatisfactory for its purpose. The court held that the goods are of the description which is in the course of the seller business to supply. Therefore, The manufacturer was liable for breach of implied condition that the goods were fit for the purpose for which they were requirement. Applying to this case, Raya Sternberhat manufactured household goods. Dini wanted to buy an oven for her bakery, and Ramli, the retailer, recommended an oven to Dini. Unfortunately, the oven sold to Dini was defective and caused an explosion to her bakery and causing self burn to her and her workers. Since Raya Sternberhat was in the business of household goods, they were responsible for ensuring that the oven was fit for its intended purpose, which is baking. Since it wasn't, they breached their obligation, resulting in the explosion and injury. Therefore, the third element is fulfilled. In conclusion, since the law is fulfilled, Dini can seek personal injury and property damage toward Ramli.